where members of the target group sometimes choose to react to that by appropriating the term and in some way reinterpreting it to defang it from some of its disparaging power. And we have, in the case itself and in society, debates outside of the law about the effectiveness of the appropriation reaction, and the degree in which we can regulate these forms of speech outside of the First Amendment. So here I'm thinking about on campuses now, we have codes of conduct that regard certain uses of language like this to violate a code of conduct. We have critics in society calling that an overstepping, a political correctness that's gone wild, in some way saying that regulation of language is inappropriate. In the workplace, use of terms like this can give rise to hostile work environment claims, so that there are ways in which the law indirectly can regulate the use of speech like this, even when it cannot directly regulate it. So, and of course in society, we have norms about acceptable behavior, and one of the issues is to what extent are uses of phrases like this acceptable or not, whether in jokes or otherwise. And so I want to start by welcoming Simon Tam. He's the leader of the band The Slants, which is the petitioner in the case. And it is the choice of that name for the band that is the subject of the dispute and the government's refusal to give it a trademark registration. And I also want to welcome our own Professor Phillips, who is directing our intellectual property clinic and who has worked extensively on issues around the name of the Washington football team, representing Native American challengers to the trademark registration in that case. A word or two about Simon. So he's the founder of the first and only all-Asian American dance rock band. And he's a social activist dedicated to raising awareness of racial disparities, social justice, and issues that affect the Asian American community. In addition to being known for this case, he's been known for his social justice work, has given TEDx talks on systemic racism, and has been on the TEDx stage 10 times as a speaker, performer, and MC. He's joined by some of the other members of his band. Are the others coming, or just the one?
I think they're getting food.
Good for them. And Simon's been all over the media today. He talked to Nina Totenberg earlier today and was talking to the local affiliate out in Portland, Oregon, via the NPR station here. So Simon, thanks for making time. And they have a gig tonight, so he's not done. And Professor Phillips has worked, in addition to directing the program, she's our leader in the communications law area. She teaches the class, has deep relationships with the FCC, and has worked on issues about the appropriate use of language, both in this context, but also in the media context, and has a sort of long history of social justice work around language and media. So I'm now done talking because it's time for you guys to talk. And Simon, you've told the story about why you chose the name of the band multiple times, but in this context, let's advance the conversation a little bit. So there are members of the Asian American community who respect the work you're doing, who agree with your values, but feel like this method of appropriation ends up just reinforcing terminology like this rather than defanging it. What's your response to folks in that debate, Ben, and how have you come away from those kind of conversations?
Sure. So to be clear, we actually applied for trademark registration twice. And in our first application, we actually had a number of experts do quite a bit of work around that issue. In particular, we did a couple of independent national surveys, and they actually found that 92 to 98% of Asian Pacific Americans and Islanders support our use of the name. So that being said, that there's quite a number in our support. I never have claimed that all of them do. Our community is incredibly diverse. It is not a monolithic group. And we might react to words, imagery, and other things quite differently. Excuse me. When I work in terms of racial justice, I think about not only intention but impact as well, and that's something that's incredibly important to me, and something that I've spent many years considering before even advancing this particular case. When you look at how reappropriation works, it's fascinating because it is an effective method of creating social change that is indisputable. Every scientific study ever conducted on it shows that reclaiming a language can destigmatize slurs and empower a group, especially when it's a self-referential use. Not everyone has to agree with that particular process, though. I believe that when you talk about working with marginalized communities and you talk about institutional and systemic issues, that mechanism is so complex that it often requires many different tools to dismantle it. Reappropriation is just one of them. So even for folks who disagree with me, we can both agree that it is still advancing justice. It's advancing that conversation forward about how laws, how policies, and even how our culture can disproportionately impact our communities.
Great. And let me just ask, I mean, in the appropriation debates, the other point is sort of who gets to use the words and when, right? And certainly around the N word, there've been a lot of where there've been appropriation by a variety of bands and other folks, and sort of the in-group, out-group usage of these terms. Do you have any guidance for people who want to be correct without being sort of disparagingly politically correct? What's your sort of guidelines for people in this new linguistic environment?
Bottom line, ask.
Yeah.
Ask questions to those particular groups and the reference groups. Don't just make assumptions that something is or is not offensive to that particular group. I think with that's one of the fun things, and one of the most powerful things about reappropriation is that it is confusing. It's deliberately confusing because when you can kind of make that the seat of power kind of questionable, it all of a sudden makes people feel a little bit uncomfortable. And for marginalized groups, that's an important concept, because when you believe you've been living in a society that favors certain people based on their gender, their sexuality, their race, whatever it might be, when all of a sudden they're not sure how to handle the issue, that means our communities get to step forward and take charge and lead that conversation.
Interesting. So, Vicki, let me, we just heard Simon quoted X percentage of the reference group are not offended, and therefore,
only in my case.
In your case, only in your
cases.
case. So we are told by the Washington football team that although they are not it is not a reappropriation usage, that only 10% of Native Americans find the name of the Washington football team offensive. It's got a long history, a long tradition. What's the problem? How do you respond? Outside of the law, we know how you've responded, and we'll hear from Jesse Witten on the panel who's representing them in the Black Horse case. But outside of the law, based on your sort of broader discussions with our Native American clients and communities, what can you report about those experiences?
Yeah, well, that figure is out there. I don't know that I agree with that figure or accept the methodology of the survey that is older in 2004 and the survey that the Washington Post undertook themselves, I think just last spring. It's funny with it, just talking about the survey, if you sort of interrogate the people and the quotes that accompanied that survey, you see the sort of ill effects of the use of that mark on the very language they use. Things like, at least people are paying attention to us. Things that just sort of strike me as not statements that strike me as belying how they really feel in the reported results. But yeah, I mean, I can't think of a more sympathetic person to challenge 2A than Simon, because I totally agree with you, and I think that 2A though should be, the government and the Patent and Trademark Office should be able to distinguish between sort of irony and reappropriation, and taking a term or a symbol even, to liberate oneself and to teach others, and one that is clearly taken, and for not that purpose, and offending people. So I support and you'll hear more about the legal argument today. But I think that 2A should be more robust to be able to. I just wanted to put it out there that I agree, and that in your case as applied, that it was a bad decision by the office. So I did get the opportunity to work a little bit with my great colleague Christine Farley and Rebecca Tushnet, who will be here later, and Jesse Witten, who you'll hear from, who's worked for so many years on this case pro bono, on the trademark issue when Suzanne Harjo first challenged the Washington football team's mark under 2A. I mean, it was an avenue used to stop an injustice. You know, there are many potential avenues, but that was one avenue that she found was available to her. And so after toiling in the sort of the trademark law, First Amendment legal piece of it, I started to really think that I didn't really know about the harms. So like Simon, in a way, I decided to go out and sort of talk to Native youth about this effect on them, because I had done a lot of work, as Michael mentioned, on media, children's television, and hate speech in media, and how it affects mostly our most fragile members, or most fragile viewers and listeners. And the study that I did and the report I released for the Center for American Progress with a Native staffer there, the stories of harm, the actual harm, it's about the farthest thing from what Simon is trying to do and his band is trying to do with his mark. The harm of the use of Native imagery and slurs by non-Natives is scientifically, and the social science proves that it's really harmful, especially to Native youth. And the firsthand accounts we got were quite moving in that regard. And it's not just in Washington and the football team here. It's these mascots are throughout interscholastic sports. And thankfully, in the civil rights era, and with sort of burgeoning awareness on campus of the harms of this, many mascots were changed. Some that you probably are familiar with: Oklahoma, Syracuse, Dartmouth, Stanford. And in those stories that I did with my students here at the law school, in the white paper we wrote and the stories we wrote for a conference that Suzanne Harjo had at the Smithsonian, you saw sort of all the reasons for change. Dartmouth was founded with a real institutional mission of teaching Native Americans. And it just became in those voices of the students and the natives who were to dress up and dance as Little Red at the Oklahoma halftime show. You still hear in this report we did in 2014, you still hear stories like that in interscholastic sports today. Not so much college, because the NCAA stepped forward and said, we won't allow this. You won't do any post-tournament NCAA sanctioned things if you have mascots like this. And so the difference is so stark, because the non-legal research and the social science interviewing I did really demonstrated to me that there's a true harm here, and it's self-esteem, and it's not just to Native Americans and Native youth, it's to us. And one of my favorite quotes that I came across was Kevin Gover's. Kevin Gover, who's the head of the National Museum of American Indian here, said, the Indian you most often see in Washington, D.C. is at a football game, at the expense of real Indians, real history, real culture. The petty stereotype has become expected. Because we don't know, here in this city, we don't know many Native Americans. So that becomes reality to the football attendees. And it's not just the people who go to the football game, not just the 60,000 fans that cram FedEx Stadium. It's the 10 million households who watch football games every weekend.
Thank you for that. And Simon, you commented in the Washingtonian piece about, the ways in which you felt the Washington football team name. You want to, you're on the same side on the constitutional issue with respect to the trademark law, but not in terms of the appropriateness of the use of this terminology in society more generally. And talk a little bit more, other than the reappropriation strategy, you've also worked on self-esteem within the Asian American community more generally. Maybe, is there anything about what Vicky's saying is happening among Native Americans? What's your experience been more generally about the ways in which, as you described, marginalized communities are feeling that the names by which they are referred is contributing to that sense of marginalization over and above the economy and other things?
Sure. I mean, I think it's a common experience amongst many marginalized groups when you don't have control of your own identity, when you're labeled in a way that you disagree with. We should allow our communities to have a right to define what's appropriate for ourselves. And in this particular instance, with you have a racist football team using imagery, using human beings as mascots, that I believe is ethically wrong, and then who aren't able to control their identity. And then on the other side, you have Asian Americans who'd been using this term in a self-empowering way for decades now, and the government says you can't do that either. So it's been it's a very complex, very nuanced issue, but I think it's bottom line. It's about control, and it's about whether or not our communities have a right to define that role, like of what role we want to play in society. That right should be reserved for our own, and our own community is not excluded from this practice as well. There were actually numerous sports teams called the Orientals, and as an Asian American, I would say that's one of the most derogatory terms that one can use for Asian Americans. Those have kind of adjusted over time. Many of them became the Dragons or something like pseudo-Asian. But yeah, I think there is a profound effect when we allow this to be kind of pervasive in our society. Of course, we have disagreements of where that change should take place, whether it be at a trademark office, whether it's in the marketplace or at other places. But I think it is incontestable that there is a dramatic effect on people who already have kind of feel like second-class citizens when they don't have that control.
I'm thinking about maybe reflect for a few minutes. We don't have that much time, but I mean, there have been a lot of changes, right? So I grew up in this city, and I knew and sang the Washington football's fight song because I was 8 years old, and that's what you did when you were a football fan. And we're now in a moment where members of the Washington Post editorial staff have chosen not to name the team by its trademark, and other members of the media have independently made a judgment that their use of the term, they don't want to be complicit in the harms that you just described, and that's completely new. I mean, that was not even on the radar as a possibility until relatively recently, and I'd give the folks involved in the lawsuit a lot of credit for helping to push that conversation forward so that even if you don't win in the court, in the larger court of public opinion, I think there's been a noticeable shift in that particular issue. But more generally, there's been a lot more sensitivity, at least on college campuses and in some parts of society, around the use of terminology. And now we're hearing at the same time a kind of pushback against that we've gone too far, that I mean, come on, you grew up and you told jokes about another ethnic group. It was part of the American story. And when I was growing up, kids would tell jokes about people of Polish descent. And at some point, I think that point of view would say we have to be allowed to talk about attributes that a particular members of a particular group have in our humor, in our ways of interacting. And now we feel like we've been straitjacketed by speech police who jump on us every time we make a little misstep, How would each of you respond to somebody who is feeling like at this moment in time, they can't speak their own mind because they'll be told that they're being racist?
Do you want to?
Yeah, well, in the case of the Washington football team, it's not an attribute. It's a genocidal slur. It's not a name that's derived from the color of the skin, as most people think, as I thought until I got involved in this. It's a genocidal slur that meant the bounties, that meant the scalps for killing a Native person. So that's a little different than a teasing about an attribute. That's a whole culture's history. And what Simon said about mascotting. I mean, mascotting by its very definition, but what Simon does is art and expressive. What the Washington football team does, in my mind, is commodification and commercialization of a cultural identity and a genocidal slur. I mean, mascotting in and of itself means something little, diminishing. Suzanne Harjo herself has recounted going to a Washington football game and being petted, people asking to touch her hair. It's from the turn of the last century and centuries before. When you conquer someone, you take their uniform, right? We do it in sports when the rugby or crew, we take the other team's shirt, right? We wear the uniform of the conquered. And that turn of the 20th century, that's what colleges and sports team did. They wanted, and a lot of Native historians have written about this, they wanted to define American by associating with the savage other, but being different and being more civilized. And it's just puts Native people, in the case of this team, in a sort of mummified, that's the way they are. They're savage, they're fierce, they look, they're caricatured in their look. The mascotting of them diminishes them, and that's why it's sort of a different thing than an expressive art or a sideline a side joke among kids on a playground. This is a massively commodified image that puts Native people down. And I just don't know that they would have the ability to reclaim that term given the years and years and sedimentary layers of being put down by this term, and with such a strong commercial stranglehold on it by this team.
I think in regards to that kind of the pushback that people say of political correctness being kind of taking over, I would argue that those people are free to say whatever they want. You can use racial slurs if you want, but you have to pay the price. And if that price is losing social credibility of people calling you out on those things, that's fine. That's part of the price to be paid. And so nobody is stopping those individuals from making those jokes that maybe are crude or maybe that perpetuate racist stereotypes or that sort of thing. We were actually just having this discussion as a band yesterday. Someone was interviewing us and asking us like what we thought about Steve Harvey making a comment that Asian American men were basically undateable. And a lot of us were like, well, first of all, that's just bad comedy. In fact, I was like, is he a comedian? I didn't realize that. And we were kind of, our first response as appreciators of comedy and art was like, if you're going to come up with a joke, come at it with good comedy. It's got to be a sharply written joke. And then, of course, you could backpedal and say, well, that's not my intention and that sort of thing. But again, it's kind of like, as I said earlier, we have to kind of look at the difference between intention and impact. If someone's intending to tell a joke, we have to think about who is impacted by that, who's hurt. And do we really want a society where we could say, you know what, let's just ridicule marginalized communities as much as we want? To me, that's the ultimate form of privilege, that we should be able to say whatever we want, even at the expense of others. So I don't know, there's a lot of thoughts about that.
Yeah, okay. Well, I think at this point we probably need to wrap this up, and if folks have questions, maybe there'll be a very short break, but we're going to start the legal panel at 4:15. I know you didn't say you wanted to do this for promotion, but tell us where your gig is tonight in case people want to remember the name of it.
That's the Electric Maid Community Space. I think it's in the Tacoma area of DC. Is that an area?
It is.
Okay. the Tacoma area. We have what we call a conversation and concert, where I actually tell stories about what it's been like to perform in this band. A little bit of legal stuff for the law geeks out there, of like what it's been like as an applicant to go through almost a decade of fighting the law. And then we get to perform, because that's what we do. We're artists and we make music, and so we're really happy to share some of our songs with you. So,
All right. Well, thank you so much for coming out and chatting, and we look forward to the discussion in a few minutes. And could we please give these folks a... Okay, we'll be back in about 10 minutes. Thanks very much. Absolutely.
Now we get to hear the technology in your case.
what's that?
Now we get to hear the...
Oh yeah, all the fun stuff.
Did you get a sense from...
I'm going to load up the slides.
No, not even that.
Thank you so much for coming. That was really great. It was just wonderful to have you.
Doesn't work.
We have an overabundance of lawyers.
I work
Very nice to meet you.
nearby.
I was just wondering, 'cause like Professor Carroll said, I grew up
Took the
here.
opportunity to
I've been,
take the day
you know,
off.
and now.
See your hearing
so
and
I
then
need to say
come to
more,
this.
but- And
Well,
I'm kind of torn,
Yeah,
because obviously.
very good. It was
I had no idea about any of that.
I know. That's because both hearings had
Any of
one.
that.
Yeah.
Literally, just like singing the song, but, you know, when they bring it to the forefront, they bring it to your conscience, you know, you want to stop, but I guess my question is. Oh, sorry.
The webpage just still runs. You're going to come to the side.
Well, then you are.
Oh my
But I guess my question is.
Yeah, no, I have...
All that lying.
How many both sides?
That means it was a good spirited argument, you know?
This is a pretty intensive. Who else is?
If she-
Right. What's her? Amanda Harcourt.
Well,
No, her counsel.
her counsel from
Jesse
Rick
Whitten,
Bennett.
yeah.
Right. Were they, I assume they were there this
That's
morning.
what I'm asking.
Yeah. And then they were lunching in the room right next to us.
I'm pretty sure Black Horse is.
Happened to have
So this is 6 or is this 6? One, 2, 3. Okay, so I'm on.
You can stay where you are.
I'm here. Well, if we get.
Oh, really? Yeah, no, that's what I told you. I said that.
Oh, yeah.
This over here.
So,
Jesse is that guy there, so he's gonna be.
did you basically move down here for the last 2 weeks?
Let's see.
months. Yeah, we were down here for several months.
Yeah. You were just going back and forth? Yeah. Yeah.
No one.
Oh, great.
I was working closer. I think right now we'll put you down next, you'll be here.
But I saw that did he finally get a big round of financing?
Thanks very much for coming down.
Yeah. Oddly enough, though. Before, which doesn't include any litigation costs or costs for, anything it does. We actually got.
Jamie, yeah. Are you on faculty here? Hi. Good to see you. I actually get to American like at least once a year, sometimes twice. I was just here 2 months ago, I guess, talking about some other case. Yeah. Well, I've been at Cato almost 10 years now.
All right, we'll ask some tough questions. Don't worry. Get ready.
Don't let my snoring bother
I'm sure it's been a long week.
You teach international law? Cool.
She's correct if you were.
15 years later.
Yeah.
you.
Hey, yeah, good to see you. Nice to see you.
No,
Yeah, sure. Let me give you my card.
Yeah, there's a.
You know, curious. They're so good about keeping their alumni network. Like I go to their Christmas party, and when they opened up their new office last summer, or their renovated, office, same place, but they had a big reception for alumni and stuff. And
I'm literally all day.
one time I even coincidentally happened to be in New York during the reception, or during a time when they had a reception. I'm like, oh, well, I'm not doing anything tonight. Let's pop over for now. So, yeah.
I remember when I was at
registration does.
I think once or twice I filed an amicus brief supporting their case.
Free expression,
So,
free commerce.
So you still have to prove.
yeah, good to see you.
Everybody has to support.
And a judgment, not necessarily, you follow. You're trying to figure out. Yeah. So it's true, it's sort of like you have, so it's a mandatory hurdle or process to go through, but it doesn't require
Right.
Yeah, I mean, I think you could spin the sentence to mean a different. Yes, it's not quite that. But it is still the case that the failure to register deprives you of the evidentiary benefits. Yeah. But you can still bring it. Because they didn't want to give the court, and they didn't want to give the Copyright Office the same power.
Oh.
Talk to Terry.
What is she?
Look on page, first 10 pages.
It's fog.
They were talking over each other.
No, she got it. Look around page 10. Right after Kennedy's questions about.
Okay.
Can I look at Sean's calendar?
Well, I can't find it, I guess, but she definitely.
Here, right, I see what she said. I mean, that's her question.
But she was inspired by us.
Yeah, although I think all she's saying is that I think you still have to apply. And the point is the court's not supposed to do the case.
We're trying to distinguish.
I understand.
Oh, listen to I guess he flies home at. Gets home
I mean,
late.
the distinction is not as big as you were hoping.
I was gonna say. I didn't
that's what
think
he
it
said.
was-
Hi.
Thanks for coming out.
Thank you for having us. I was just thinking to myself, what a distinguished panel this is. Hi, Jesse. Joel McCall.
Just the
Hey,
file
Joel.
names?
Councilman Mr. Tam.
So,
This morning.
no, well, you have to order. I just called Terry and had her contact the files.
Yeah, John
Storage.
I actually had a great conversation. I met him for the first time this summer. So we were on a panel together before the
I told you.
IPLA. And he was a real gentleman. I like Steve a lot.
Yeah.
John, Mike, so.
Hey, Mike, John Connell. Very nice to meet you too.
Good to see you.
Yeah, it was
They knew that the prior.
there was, you can move this thing 1,000 times, you're never gonna get exactly what it's.
It's all good. Equitable things against at a minimum.
Okay.
Well, like cat nap at 1, 2, 3, 4, 5.
Yeah, so it looks like they like filed it, then maybe suspended it for settlement, and then it was unsuspended, and then there was like I think maybe they got to like testimony and nothing had happened, and the board issued an order to show cause, like, are you prosecuting the case? Okay, and they didn't respond, and it was default.
No, I haven't.
Yeah,
If that is what happened, it is very
both
good.
sides got beat up.
Yeah. Yeah, I would have wanted to have been either one of you this morning.
One of the best posts, I think, was on Twitter by Helmsley. He said, it looked to me like the court wanted
Lemley,
to issue,
Michael Lemley.
Lemley. The court wanted to issue a unanimous opinion against both sides.
Were they streaming this? They're streaming this, huh?
Sweet.
Statutory case out to the Supreme Court. King v. Burwell.
An hour and 15 minutes.
Thanks.
Market practice development.
Yeah, right. Between in front of a room full of 2Ls. Thanks for the opportunity. The phone will be ringing off the.
It's live. So whatever you say on this microphone, everybody.
Can you hear everything?
They can hear you. Just want to let you know, just in case you don't want to say anything crazy.
Thank you.
Okay.
Okay.
Just to let you know.
Yeah, this is mine.
My son talked about a pizzeria today at school.
Rebecca and I appeared opposite each other on NPR this morning, and we recorded a National Constitution Center podcast earlier today.
It's not the original plan.
Yeah.
But, the Supreme Court only schedules these, like, 4 to 8 weeks out. So, you find out it's going to be, they grant cert, but they don't actually necessarily set the oral argument date. So, I think it's in December, but Christine had already scheduled, she's doing education. And then after, since we do them on the day of argument, we didn't have any flexibility in moving it. She already said yes to you. So, she was the person who coordinated the law professor's amicus brief and is working with.
How many amicus briefs do you file?
That part does not.
It increases every year. I think we're about hitting our limit. Last year we filed 65. And it's about a third in-house, a third joining other groups, a third in big law to do pro bono.
At the beach.
The breakdown last year was something like something like 15 on the merits, 25 or 30 cert stage, another 10 in the circuits, and like 4 or 5 state supremes.
I think we should just. Rebecca can do it. That's fine.
All right, I've called Professor Tushnet. I'm not sure. She's been a participant in many of our events, so this is a little unusual. But
She gets started.
she might text me, so I'll keep my phone up. All right, we're going to get started. If people could take their seats, please. Okay, so now we're going to talk a little bit about the law, and I think what I'll do is I prepared a very, very brief legal primer for some of the students in the audience who've not yet had First Amendment law, and hopefully for students on the web or other non-lawyers. it's an interesting facet of American constitutional law that the fundamental right to speak freely is so readily understood. But then when you go to the Supreme Court and ask, how does that translate into legal principles, it suddenly sounds like they're talking about the tax code. There's a lot of special terms of art that have been created. But the underlying principle is that we live in a democracy where the elected representatives represent folks and can pass laws that represent the will of the political majority. One of the roles of the Supreme Court, however, is to protect the fundamental rights of the political minority against legislation that would overstep. And the First Amendment is where that job of the court comes forward. And the court, as an unelected member of the or a group of the government, is aware that their legitimacy has to be sort of grounded in some principles that justify the overriding of the political will of the majority. And so what a lot of this terminology is about is the court articulating its principles for when it thinks Congress or has overstepped its bounds. So if we, whoops, here we go. All right, well, that's not here. So there are a couple of questions. What the court is worried about is essentially the political majority trying to suppress speech or viewpoints or perspectives that it disfavors. The whole idea is that we should have an ability to exchange ideas, sometimes called the marketplace of ideas. And so one of the roles of the court is to ensure that ability to speak to one another. So the court first asked, is the law content-based? Meaning, do you determine how to apply the law based on the content of the speech? Because the court's worried about picking and choosing types of content that is favored or disfavored. That raises the suspicion level of the court and therefore raises the burden on the government to justify its regulation. Even when the regulation can properly apply to specific types of content, the court has introduced a second test, which is called viewpoint-based. So, for example, in a case striking down a hate crimes legislation in Minnesota, where the defendant had been prosecuted for burning a cross on the lawn of a member of that community, the court agreed that you can punish expressive acts like burning something on someone else's property. However, if you pick and choose which kinds of fighting words based on the viewpoint, so the court said you're only targeting racist speech and gender-based speech, but not other forms of harmful expression that is likely to incite anger, and therefore it struck it down, saying that you've picked and chosen which types of where the content is these are fighting words, but now you've picked and chosen among the fighting words as to which gets punished. So they struck that down. So the general rule is if the rule suppresses or burdens speech based on its content, then it's subject to strict scrutiny. The government has a high justificatory burden. It has to show a compelling interest and show that the rule has been narrowly tailored and they've chosen the least speech restrictive means of regulating the content in order to achieve, to protect that compelling interest. And so you're going to hear the terms content-based and viewpoint-based or a bit in this discussion, and it's because there are consequences. If the law is content-based and it is suppressing or burdening speech, it has a very low likelihood of passing. Even if it is properly based on content, if it is viewpoint-based, it has a very high justification that it has to meet. Now, there are other categories, other exceptions where the government has more latitude to target speech based on its content, and these are three that you'll hear about. If the government is acting as a speaker rather than a regulator, the government can make content-based descriptions about what it does and doesn't want to say. That's the easiest case. Even when the government's not the speaker, but the government is subsidizing the speech, it is again not suppressing or burdening anyone's speech. It is simply choosing how to use public money in relation to other people's speech. And in general, the government has more latitude there. However, it cannot be viewpoint-based in the way that it gives its subsidies, and it cannot impose unconstitutional conditions on access to those subsidies such that it would indirectly be engaged in content suppression or burdening. And lastly, I'm putting it on this slide, you might conceptually think of it differently. Even if the content is being suppressed or regulated, if it is commercial speech, the justification doesn't need to be as high. It needs to meet what's called intermediate scrutiny, meaning only that the government interest is important rather than compelling, and that the relationship between the regulation is substantial relation rather than the least restrictive. So that's, other terms will come up, but I think you're going to hear government speech, government subsidies, commercial speech, content-based, viewpoint-based. Those are the terms of art. And the reason you're going to hear them is because the Supreme Court precedents are basically point in different directions depending on which of those boxes apply. So principles and precedents, we'll also hear about some of the cases where the courts applied these principles. And one of the interesting things for First Amendment geeks is that this case doesn't neatly fit into any indirect line of cases. And so there are at least 4 or 5 lines of cases that one might choose from in deciding how to, when the court decides the outcome of this case. All right, with that sort of baseline set, I want to introduce our speakers and kick off this discussion. To my immediate left, we have Jesse Witten. He defends healthcare providers, pharmaceutical manufacturers, and other clients at his law firm Drinker Biddle, where he's a partner, and he's also been the pro bono counsel for the Black Horse plaintiffs that have challenged successfully in the trademark office the registration, and in the district court, the registration of the Washington football team's trademark. That decision has been appealed to the Fourth Circuit Court of Appeals, where it has currently been stayed pending the outcome of this case. And Mr. Witten also submitted an amicus brief in this case as well. To his left is Ilya Shapiro, who is Senior Fellow in Constitutional Studies at the Cato Institute and the editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was a special assistant advisor to the multinational force in Iraq on rule of law issues, and he practiced at the law firm of Patton Boggs and Cleary Gottlieb. To his left is Professor Rebecca Tushnet. She's taught at Georgetown University Law Center since 2004, was previously on the faculty at New York University School of Law, and will be joining the faculty at Harvard Law School next year. And she clerked for Chief Judge Edward Becker on the Third Circuit and Associate Justice David Souter on the U.S. Supreme Court. To his left, or her left, rather, is John Connell, who holds degrees from Columbia University, New York University, and Rutgers. He was the law secretary to the Honorable Thomas Schebel. Did I pronounce that right? Schebel, sorry. The Superior Court of New Jersey and the Appellate Division, and has been admitted to practice in multiple different jurisdictions. He's got clients ranging from Fortune 100 companies to individuals in an array of commercial and employment, civil rights, and healthcare matters. And John had the privilege of arguing before the court this morning. So we'll be curious to hear what that was like. And to his left is, Joel McCall, who practices of the same law firm, who practices on high-stakes, complex commercial litigation and intellectual property disputes, including copyright and trademark infringement, cyber squatting, rights of publicity, and he has significant appellate experience as well, having been involved in the Court of Appeals for the Federal Circuit's rehearing in this case as well. All right. With that, I guess I want to start with the Petitioner's Counsel, and John, maybe tell us a little bit about, based on all these different First Amendment boxes, what is your position about Section 2A of the trademark statute, Section 1052A, which prohibits the U.S. Patent and Trademark Office from registering trademarks on a number of grounds. The one at stake in this is when the mark is disparaging. That's the magic word. So when the government refuses to give you a trademark because the government takes the position that that trademark is disparaging, you argue it violates the First Amendment. Why?
Denial of registration under Section 2A is always because the government finds the mark to be disparaging, which means that it is offensive to a third party. It expresses a negative view that the government disfavors. That is inherently viewpoint discrimination, because at the same time, mark holders with positive or neutral views that the government favors are permitted to register and therefore derive the benefits of registration, which are the significant protections provided by the Lanham Act. The Lanham Act itself is a widely available program to a broad range of mark holders who seek the legal protections of registration. And by the government selectively denying a mark holder because of the negative views expressed by the mark, that is viewpoint discrimination. That's just in a summary.
All right. And Joel, did you want to add anything to?
No, I think from a constitutional perspective, John has answered the question, so not really, no.
Okay. We don't have the benefit of the government joining us. They have a standing policy not to comment on pending cases, but I wonder if either Rebecca or Jesse, since you wrote amicus briefs supporting the government position, whether you'd be willing to just, in the briefest of thumbnails, sketch the position they took, which is not necessarily the position either of you took in your brief, but just so we can have the parties' positions that the court is going to focus on. How does the government characterize the refusal to register a trademark on disparagement grounds?
Rebecca, you want to take that?
Well, so actually, I largely did agree with the government, with the exception of a few details about government speech doctrine. But the government takes the position that this is a government program whose contours the government is largely entitled to define, that this is not viewpoint discrimination because it doesn't target a particular group for exclusion or sole inclusion in the trademark system. It protects everybody across the board, and that the government's desire not to put even a minimal official imprimatur on disparaging terms is therefore enough of an interest to sustain the regulation, given that no one is proposing to penalize the slants in the sense of sending them to jail or fining them, or in any way stopping them from using the term.
So maybe this is a simple case if that's it. I guess Ilya, you filed a brief in supporting the petitioner's position. Tell us what did you add? What was the motivation for filing, and what
we added a big full color beer label called Raging Bitch. That was a delicious Belgian style IPA. I recommend by my clients, Flying Dog Brewery. I have some copies of my brief here. Those of you who ask good questions, I might give you one.
Signed.
Sure. But the point that we wanted to make was beyond kind of the black letter law about viewpoint discrimination or unconstitutional conditions. That's an important point, that it's not that Simon Tam is being thrown into jail for using these terms, but that he's being denied a government benefit for exercising his First Amendment rights. That is, that trademark registration is an important statutory right. It becomes a lot easier to defend trademark infringements against your brand. If, as he discusses in all the news stories this week, a record label is not going to sign a band if their trademark's not registered. There are certain presumptions, legal presumptions, when you go to court to enforce your mark, that registration helps, et cetera, and the government cannot, under kind of axiomatic First Amendment theory, cannot decline to give you this statutory right based on your viewpoint. It can, in trademark law, say, your mark has to be distinctive. It can't be purely generic, like you can have Apple computers, but not Apple, perhaps. It can't be deceptive. In fact, the whole purpose of the trademark law, the Lanham Act, is to prevent deception and fraud in commerce. This kind of disparagement clause, along with kind of an immorality clause, they're related, is the lone kind of very subjective sort of aspect to the whole trademark registration process. And we try to illustrate the absurdity of this by talking, especially in the musical space, about a lot of bands that historically have either tried to reappropriate what was a slur, like Pansy Division, for example, or Niggas with Attitude, or there's a whole history of that, or simply to be expressive or to be shocking. If you're a speed heavy metal band of some sort, you might call yourself in a different way than if you're a string quartet. And that indicates something in the marketplace of ideas about your brand, which at the end of the day is what trademarks are all about. And this is our third annual funny brief, as it were. Just so we're not going to file satirical briefs in like an environmental regulation case or something else like that. But with the First Amendment, when there are absurd government actions, whether it's policing truth or truthiness in political discourse or offensive speech, it's a good opportunity to use vivid examples that as an amicus rather than as the party defending the client, that you have a lot more leeway to do.
Thanks. So, Jesse, let me ask you, although the Washington football team wished in some ways that its case was before the court rather than this case,
by the way, I always thought the solution, non-legal solution for the whole Redskins controversy is not to keep the name, but to change the logo to a smiling redless potato.
I'll root for that.
But to what extent does the presence of your case in the system, do you think, influence the way the court's looking at this dispute? And tell us about what it was you were hoping to communicate directly to them in your brief.
Well, there's no doubt that our case, and as Professor Carroll said, we represent Amanda Blackhorse, who's so far successfully been petitioning to cancel the trademark registrations of the Washington football team. There's no question that our case is hanging over the TAM case. It's especially locally. It's been all over the press, of course, in Washington and nationally for a number of years. And overshadowing our case is the N-word. And it has always been our subtle and sometimes not subtle strategy to make what is obvious even more obvious, which is if you open the door to, if you find this constitutional, the government is going to have to issue trademark registrations for everything. And maybe that's good policy, maybe that's not a good policy, but I think there are a lot of judges who will be very leery about wanting to put on the government official registry of registered trademarks some really sickening racist marks. And in our brief, we had some pictures here of some marks that were registered that use the N-word, that are really repulsive, and they were registered before the statute was changed in the 1940s to its current form, where it says that marks that may disparage persons are not eligible for registration. So, we were not that subtle about it. I can tell you that the government was felt like they couldn't be quite as brazen as we were, but we're really happy that we were brazen. And they cited to, our instead of having to cite to this stuff themselves, they were able to cite to our amicus brief. Our amicus brief was intended to complement the government's brief, as an amicus brief ought to, and we emphasized quite a bit what I think is a simplistic or a simple argument, I should say. And the argument is that Section 2A, which does not allow registration of marks that may disparage, doesn't burden the speaker. There's, we don't get into the complicated stuff about viewpoint discrimination and all the doctrines or which bucket that goes into. We argue that you don't even get past the very first base, which is the speaker burdened here? And to understand our argument, you need to understand a very important distinction, a distinction between a trademark and a trademark registration. What's a trademark? It's a word or a symbol or a combination that you use to distinguish your goods or services from somebody else's. What's a trademark registration? And how do you get a trademark? Does the government give you a trademark? No, you don't get a trademark from the government. You get the trademark just from using your words or symbols. Simon Tam has a service mark. It's a trademark for services. Simon Tam has a service mark. He has it because he started calling his band the Slants, and they had a certain symbol and word. There's nothing that this case will do to take away that service mark. What this case is about is whether that service mark can be entered into the government registry of marks. What's the value of being a registered mark as opposed to an unregistered mark, or in this case, in our view, an unregisterable mark? Well, as Ilya said, if you ever go to sue somebody for infringement, there are some evidentiary presumptions that would be in your favor if you had to file that lawsuit and prove it. In other words, it'll be easier to prove your case if it's registered. There's some other benefits as well. So if you think about it, what is a trademark again? It's the trademark empowers you to silence somebody else. It's not the First Amendment. It's an exception to the First Amendment. If you have a trademark, that means you get to prevent somebody else from speaking the way that they want to speak. So the denial of a trademark registration, or in our case, the cancellation of a registration, might marginally reduce the trademark owner's ability to silence somebody else. But silencing somebody else is not a First Amendment right. You don't get the First Amendment right. First Amendment doesn't give you the right to prevent somebody else from speaking. So that was the approach that we took in our brief. I was pleased that this morning Justice Sotomayor asked some questions that indicated that she may have read our brief, because there are 30 amicus briefs filed in this case. It's hard to stand out. And that's we all put in a lot of work on our briefs, and the worst fear is that it'll never get read, or it'll get read like this. So that's how we complimented the government. The government made the point that Simon can that nothing's preventing him from speaking, but we try to take it to another level, which is, moreover, what is this actually? How is he burdened? The only burden on him is that he's somewhat restricted by having an unregistered mark as opposed to a registered mark in preventing others from speaking.
Great. And let me ask, and I forgot to disclose in the introductions, I apologize, that I signed Professor Tushnet's brief, but I'm in my moderator role. I've walled off the amicus. And but Rebecca, if you tell us a little bit more about what you had, and on this point, you've dropped a footnote that somewhat takes a different position than the ABA a little bit on this question of what is the burden of being denied a trademark registration. The ABA's amicus brief asserts that it is without question the unregistered trademark owner can still bring a claim under Section 43A of the Lanham Act, which is the part of the law that protects unregistered trademarks. Your footnote says the court doesn't need to get into that, and it's a little more complicated than that. So as you tell us about your overall position, if you wouldn't mind, for the trademark geeks in the room, to talk about that little, the availability of a 43A action for a trademark denied as being disparaging.
Right. So our brief took the position that the court should not use this case as a vehicle to decide a very much larger and important question about the extent to which 43A is subject to the same limitations as 32 for the infringement provision for registered marks. This implicates a whole bunch of policy questions: territoriality, abandonment, deceptive marks, functionality, and this is a bad vehicle. There's another case coming up before the court, which I hope it'll grant cert on, that actually puts this straight in front of the court, that most of the exclusions in Section 2 are really good reasons to deny enforcement of a claim under 43A as well. The way I put it is, it's not wild-eyed lunacy to conclude that, the remaining ones also express congressional policies like against disparaging marks. Now, there are reasonable arguments to the contrary, that you should still be able to bring a 43A claim, but that requires you to have a very detailed theory of what trademark is for, and you saw this even at the argument where people were saying, well, of course, some of the exclusions in Section 2 would also kick you out of 43A. And let's not decide that. I frankly think either the burden is enough to trigger invalidation, or it's not. That is, I think that regardless, that even if 43A doesn't provide a mechanism, the same rationale should control. So that's another reason the court shouldn't resolve it. In terms of what we were trying to do, I was interested in putting in a structural trademark perspective, given that many of the arguments, like the 43A argument, have implications beyond disparagement that I wanted to make sure the court was thinking about, regardless of the way it resolves them. So trademark, as we've just heard, is a right to suppress speech, right? If Tam gets trademark protection for the expressive aspects of his mark, he's able to suppress other speakers, including a racist band using the term to express its racism, using it as expressively as he's using it. So this characteristic, both of trademark and of trademark registration, means that First Amendment analysis targeted at traditional punishments, so a bunch of the cited cases and modes of analysis, those are inappropriate. There's no neutral baseline here. Trademark registration is a government intervention into the speech marketplace. And that point also highlights that what the government is trying to do is regulate only the registration and commercial aspects of a transaction, not the expressive aspects of the mark. So this is how we get to the unconstitutional conditions argument, which is what I think is the best way to analyze this question. Denying somebody registration does not deny them a government benefit outside the contours of the government program itself. So unconstitutional conditions is a doctrine that prevents the government from attempting to leverage its power to confer a benefit to change your constitutionally protected behavior outside the program. The government, we know, can decline to pay for abortions, but it can't, under this doctrine, decline to provide other health care to someone who exercised her constitutional right to abortion outside the government program. Likewise, Simon Tam can register trademarks in logos, names, any other features that pass the registrability test. If he were instead denied any trademark registration at all until he changed the name, then it would be an unconstitutional condition. But that's not what's going on. We also wanted to make the point that this really isn't viewpoint discrimination. And I think the reason is this. Why is viewpoint discrimination bad? Like, what makes it different and worse than content discrimination? The reason is it targets a particular group for suppression, or people holding a specific set of beliefs for suppression. The disparagement bar just doesn't do that. Hating gays is a viewpoint. Hating is not. And I think in trademark, you can see this actually by comparing it to the idea of materiality, making an effect on a consumer's decision. So in trademark, you refuse to register a deceptive mark, but not a deceptively misdescriptive mark, as long as the deceptively misdescriptive mark has trademark meaning.
What does that mean in plain English?
Yeah, this is the fun part. The adjectives and the adverbs mean different things. So basically, if a name fools you about a characteristic of the product that nobody would care about, so if, say, a car polish says it contains wax, but it doesn't technically contain wax, but it still polishes the car, that is deceptively misdescriptive. Like, it says wax, it doesn't have wax, but on the other hand, you don't care. On the other hand, A deceptive mark, like super silk for clothes not made out of silk, discloses a feature of the product that people would care about. People care whether their clothes are made of silk or not. So hot wax is registrable once it develops trademark meaning for the car polish. Super silk is never registrable. That too is actually about how the target group or how the target group of consumers perceives it. It seems to me that if a blanket ban on disparagement is viewpoint-based, then a ban on material falsehoods and not on immaterial falsehoods is also viewpoint-based, because it depends on whether consumers care about the feature you're discussing or not. I don't think that makes any sense. It is definitely content-based, as is the rest of the trademark set of trademark bars, except for utilitarian functionality. But I think that's okay, given that in order for a trademark to function, we need to make these distinctions.
Interesting. So as you can see, there's this First Amendment expertise coming and this trademark expertise coming. Court's looking at it primarily as a First Amendment case. And I think
I do agree with Rebecca. This whole thing turns on unconstitutional conditions and understanding what what's being given up and what rights are at issue. Some of this, I think, discussion is kind of opens up this Pandora's box about the scope of intellectual property more broadly. I mean, that's a whole separate discussion. How strong or the scope of trademark protection should be. I mean, my perspective is if you're going to have this system of registration, and it's not the government speaking, it's the government simply administering a system that other people create to protect their own intellectual property, then it can't discriminate in this way.
Go ahead, Joe.
There's a lot to unpack in terms of what's been said, but one of the issues I do want to address is this notion that Simon Tam has not been burdened. This has come up, and Rebecca has addressed it, certainly the government has addressed it. A couple of things that I think we need to keep in mind that are really very important, at least in the way that we have put forth Simon's case. The first is that this is a facial challenge to a constitutional provision, and that's important because what we are saying is that in all instances, Section 2A is discriminatory. You'll have to take my word for it for those that are not First Amendment scholars. I certainly am not one, but I've come to learn it, that when you have a facial challenge, you don't have to necessarily demonstrate the individual is being burdened. Be that as it may, Simon has been burdened. So what you'll hear everyone say is, but precluding him from gaining a registration does not preclude him from using the mark. And trademark attorneys, I see my friend Eric Pelton in the audience will agree with me, that is a fallacy. And it's a fallacy because it presupposes that he can use the mark provided two things happen. Provided that he is not second in time, remember trademarks are property, first in time, first in right, is not second in time in a given territory. So when people say he's free to use the mark and he's based in Portland, Oregon, that presupposes that someone doesn't beat him in using the term the slants in Chattanooga, in Milwaukee, or other places where he may not have the benefit of the registration. What benefit of the registration am I talking about? One of the 7 or 8 benefits, and there may be more, that one gets with a federal registration is nationwide priority. If Simon gets his registration, no one in all of the United States may use the slants in connection with music. And there's value there. So when people say he can use the mark, he can't. He can't. And so if the fallback is going to be, and now I'm segueing to a different argument, let's look at 43A, which allows that you don't have to have a registration to enforce your mark. For the reasons I just provided, that's not going to get him there either. So I think when we say, or when the government says, or when someone says he hasn't been burdened, I think quite that just isn't under trademark law. And even First Amendment constitutional law, for the reasons I mentioned, by virtue of being a facial challenge, I just don't think that's accurate.
So the burden you're saying is that it's harder for him to silence people outside of Portland?
I'm saying if you're going to contend at the end of the day that he's allowed to use the mark, okay, which has been the government's position, It neglects the fact that he may not be first in all of these other territories. And by virtue of not getting his registration, he does not gain nationwide priority, which is what every trademark owner, among many other things, values.
No, you're certainly better off with the registration, for
Sounds
sure.
like you have a First Amendment problem with trademark law altogether.
Trademark law is, I mean, I'm not making this up. The Supreme Court has said that trademark law is a restriction on speech. It's an exception to the First Amendment. By the way, it's also said that about copyright.
It's not a restriction.
The Gay Olympics case from the mid-1970s, where a group in California wanted to hold some athletic games that they would call the Gay Olympics, were enjoined from calling their activities the Gay Olympics because of a statutory trademark that the U.S. Olympic Committee had. In that case, the Supreme Court said that although this is an exception to the First Amendment, it passes muster under as a legitimate regulation of commercial speech, because it was if we'll move to the right slide, it met the intermediate test for commercial speech regulation that the court had. So in other words, it was okay, the law that allowed the U.S. Olympic Committee to silence the people who wanted to use the words Gay Olympics was okay because it advanced a sufficient government interest. But yeah, I mean, there's no question, Ilya, that trademark is an exception to speech. It's an exception that we allow because it has benefits.
Okay, but none of that has anything to do with whether a particular mark is registered.
None of that has anything to do with whether a particular mark is registered. Well, the statute says what's registrable. And if you can't register, if a mark is not registered.
Right. But bracketing the idea that all intellectual property law or copyright and trademark is about silencing others or violates the First Amendment or what have you, bracketing that question. And believe me, within the libertarian community, we have these debates about intellectual property all the time. But we take the law as given, and the question here is, it's almost an equal protection one. Can you, based on the type of speech or your perspective that you're trying to assert with your mark, be denied because the government doesn't like it? And I'm saying, let the marketplace decide. The government shouldn't be deciding what's disparaging or what it doesn't like or what's appropriate.
Right.
Hold on for a second. I want Rebecca she had a quick response on the priority point, and then I want to move, because as energetic as we are in persuading this bench, the court has been submitted to another group, and I do want to hear a little bit about what we can learn from the argument about what that group thought of these arguments. So Rebecca, make the priority point, and then I want to...
Well, it's actually a follow-up to Jesse's, who said, so the question is, why wouldn't these other slants have First Amendment rights in territories where the Portland slants were completely unknown? And the point here is that the rationale cannot be about protecting consumers, because by hypothesis, the Michigan slants are the ones who are known in Michigan, and in fact, it actually harms consumers to take them off the market. So nationwide priority is a derogation from the common law. It's a creation of rights in places that never existed before, and in fact, it's actually about helping businesses manage their relations to one another. It's not directly about consumer protection. So it's important to recognize that the Lanham Act serves multiple interests, and one of them may well be, the avoidance of discriminatory treatment in commercial communications. The other thing I would like to just say is, I actually hate the Gay Olympics case. I think it's distinguishable, and it's my reason is actually almost the reverse of Ilya's. So he says, bracketing suppression, we should ask whether you should be denied rights here. And I'm not sure you can bracket suppression, since that's the entire right at issue. And I find it is very interesting that we are talking about denying registration based on the non-source indicating aspects of trademark, the other communicative functions they have. The reason that I find that important is because all the other exclusions, with the exception of utilitarian functionality, work that way too. So that's why I think I am hopeful that the court, even if it upholds the Federal Circuit, will take that into account and explain very clearly what it thinks is going on here.
All right. So John, it was an interesting morning. The case has now been submitted. It was what we call a hot bench. I was unable to join you at the argument, but when you read the transcript, you had 3 justices all trying to ask a question at the same time. First Amendment cases tend to draw that kind of energy, and intellectual property is an interest of the court, so that when you bring the two together, it's not surprising. But what was it like, and what's your view about the kind of reception that your arguments got before the court today?
Well, again, just because the case is pending, I don't want to comment
Understood.
too broadly about that, but I will say, I said to Ilya before we began here today that probably one of the most accurate postings I saw on the internet today was a tweet that said that it seemed as if the court wanted to rule unanimously against both sides.
All right. Well, the Federal Circuit has not had the best track record at the Supreme Court, so that may be part of what's going on there too. But why don't we stay with the petitioner's case? Ilya, what was your view about sort of the reception of the petitioner's argument and your supporting arguments?
Yeah, it seemed like the court was struggling with how exactly to write this opinion. Generally, you don't win or lose a case at argument. But I think the justices overall weren't satisfied with either the government or the petitioners in terms of how to set a bright line for what they're going to do, here. Just in terms of counting votes, and luckily I'm not paid for my predictive abilities. I don't think that's possible with the Supreme Court. But I think that there are 5 votes for the petitioners, those being Roberts, Kennedy, Alito, Kagan, and probably Ginsburg. Breyer, I think, is on the fence. Sotomayor, I think, is leaning towards the government. Thomas was silent, as is his wont. But of course, Thomas was the deciding vote on the Confederate flag license plate case last year or 2 years ago, joining the liberals without a separate concurring opinion. That case, I think, is distinguishable, the license plate case, because it's not actually, a trademark registration. It's not the government. Nobody thinks that every trademark is endorsed by the government. It's not like the government is endorsing such venerable brands as Take Your Panties Off and Capitalism Sucks Donkey Balls, and that's just the tamest ones of the tens of thousands that are in the 18-page appendix of the Pro Football Inc., that's the Redskins brief. That was kind of funny, but it kind of shows all of these trademarks, and in no reasonable world would you understand the government to be speaking. Anyway, that's how I would distinguish the Confederate flag case, and maybe Thomas would as well. I don't know, but anyway, I think that there are 5 votes for the petitioners, and 5 is all you need. But again, that prediction is worth what you're paying for it.
Yeah. And Jesse, what was your takeaway?
I have to agree with John. I felt like the court wanted to rule unanimously against both sides. This is, and I have to agree with you, Professor, this is a case that does not fit, obviously, into any established First Amendment doctrinal bucket. They're going to have to really figure out where to put this. Maybe they've decided. I've actually felt like a surprisingly large number of them seem to have an open mind from my sense of what they were, or let's say undecided still. But I really have no instinct about how this is going to go. And there are good arguments, and there are a lot of weaknesses on both sides.
Interesting. And Rebecca, when you give us yours, in particular, Justice Kagan strikes me as one of the minds in the court who draws some of the sharpest distinctions. And she appeared to be quite hung up on this content-based versus viewpoint-based sort of characterization of the denial or of the disparagement standard. And when it was presented to her that, well, your argument is that it's only content-based because it prohibits any disparagement of anyone. So a lot of the ways that viewpoint discrimination was being treated is it permits you to say nice things about particular people, but you can't say disparaging things, and therefore you're picking one viewpoint over the other. But in your brief, the argument was, no, you're being uniformly equal, that you can't be disparaging, and that's what we do in libel law. Justice Kagan was presented with that and almost batted away. She just said, well, that's historical. And so I wonder if you could talk a little bit more about that quick. What should we read into that?
So a couple of things. I mean, I will give no prediction whatsoever because I also think you can't tell. So I thought that was a little facile because there's still a question of, how do we understand that? Is it an example of viewpoint discrimination? Is defamation law viewpoint discrimination? That seems weird to say. It seems like defamation is a category of things that is different than non-defamation, not a specific set of viewpoints. And I take the point that they're historically unprotected, but we still might want to take lessons from, what is historically unprotected and why. And I go back to what I think the Solicitor General came back to is, why do we have viewpoint discrimination as a doctrine? Right? We're particularly worried about certain kinds of government interventions into the market, and they're ones that put the thumb on the scale of some group or against some group. And I don't see that this does. So there's this moment in RIV versus City of St. Paul where the Justice Scalia says, look, you can't force one side to fight by Marquis of Queensberry rules while the other side is allowed to fight freestyle. And that is not this situation. If that's what viewpoint discrimination is, then nobody gets to fight freestyle, which seems different. But that being said, if you called this viewpoint discrimination, would you create huge problems with doctrine? Like, it's not traditional viewpoint discrimination, but this is unusual enough that I can't say it'd be hugely disruptive to call this viewpoint discrimination too, because there are no obvious analogs. I think it creates some conceptual problems, but the court has papered over far worse ones in the past.
Defamation is kind of beside the point as well, because you can't have group defamation, whether you're talking about blasphemy in the religious context or other kinds of groups, and you can't use a person's name as a mark without his or her consent regardless. So this actually came up, Justice Sotomayor asked, let's say, I don't know why she picked Donald Trump, and maybe she was trying to have her cake and eat it too, but she said, before Donald Trump was a public figure, began the hypothetical, could you trademark Donald Trump as a thief? And the answer is no, not because it's defamation, that's a kind of separate analysis, but because it involves the name of a particular person, which you generally can't trademark, again, unless without their consent in certain other circumstances. So the parallel in this context wouldn't be the slants versus, Asian Americans are great. It would be if Simon Tam had a big musical rival named, I don't know, Johnny Chang, and he wanted to trademark Johnny Chang is slanty-eyed. That would be the parallel, and that may or may not be defamatory, but it also is not registrable because it involves the name Johnny Chang without his permission.
Well, so actually, and this is where it would be so nice to have some, IP expertise actually in the people who are arguing it. The legislative history of the Lanham Act contains about one line about why they added in disparagement. And it is precisely to avoid false associations. Interestingly enough, because the provision Ilya is talking about covers only living people, not dead people, and the reference in the legislative history is to Abraham Lincoln whiskey, which this person did not want registered, the congressperson talking about this. So one of the ways to see the disparagement bar actually is as a counterpart to no personal name, no false connection, the sort of equal, like you can't disparage, and also you can't praise to the extent that that you don't have permission to do so.
And I can't help myself as a music guy to drop in that the name of the band Better Than Ezra was created at a battle of the bands when the group hadn't figured out what their name was, but the local popular band was Ezra, and so they decided to call themselves Better Than Ezra. But anyway.
And let me just add to that very point, though, about Abraham Lincoln, Gin. That goes back to the original legislative history, and that was absolutely cited in our briefs that were submitted to the court, but not in the context of defamation, but in terms of the then emerging tort of privacy, that being the right of publicity. And that has not developed, contiguously with the IP jurisprudence over time. So that it's a different animal entirely.
All right, well, we have not that much time left, but I'd like to open it up for questions from the audience, if anyone's got any. We've got about 10 minutes.
Because this is really an easy case. It does lend itself to, one side being right and one side being wrong.
Sir?
Given the difficulty the court seemed to have with the bigger issues, I was a little surprised, John, that you spent no time at argument on your alternate ground for affirmance that the mark isn't disparaging.
The
Maybe you
vagueness
don't want to
argument?
talk about.
No, he's talking about you're talking about the constitutional avoidance argument.
Yeah, right. I mean,
Well, there's two parts to it. One is that, so the first part of it, that slants here is not, it's context versus intent.
Yeah, well, I mean, again, those were arguments that were not identified in the question presented, and it was just a decision that was made that since the court was teeing up the First Amendment question, that was what we needed to address. If they wanted to explore those other issues, we would take their lead.
And Paul, in fairness, he wasn't asked a question on that score, so obviously.
I mean, it obviously was a tactical decision not to mention that at oral argument.
Right.
I don't know if you want to, I guess you've answered that.
I don't think he had a choice. They were pounding him with one First Amendment question after another. That's
Well,
what
actually,
they
he
wanted.
sat down with time remaining.
What's that?
He sat down with time, it sounded, I was in council room, I
He had a
didn't
few
get into the
seconds
main
left.
courtroom.
Yeah.
It seemed like you had time left.
I was surprised the court wasn't more interested in the vagueness issues, because there was a lot of joining of that issue in the briefs. That the idea that there's no real direction to the trademark examiner about what's acceptable and what's not. The San Francisco Dykes on Bikes brief, I think, illustrated this very well. With their own battle, that is, finally they got their name trademarked, but their logo was rejected because they had their name in it, which was kind of bizarre. Also, what was it? Oh, right. The PTO denied trademark registration for "Have you heard Satan is a Republican," but granted it for "The devil is a Democrat." I don't know if that was political bias based on who was in charge of the PTO at the time. Or look at this. This is from the Redskins brief again. Registered marks include Yard Apes Landscaping Service, Afro-Saxons and Dago Swag Clothing, Baked by a Negro Baked Goods, Crippled Old Biker Bastards Clothing, Yid Dish Online Dating Newsletter, Kraka as Skateboards, Retardopedia Entertainment Services, Boobs as Beer Holders, the JJ Hat Party Hats, and Match-a-Snatch Playing Cards. Now, those seem pretty disparaging, much more than the slants for that matter, and yet...
JJ seems disparaging to you.
I don't know what playground you grew up in, but we had Asian kids, and I've never heard I mean, intellectually I know of the slur slants, but anyway.
Yes, but I've never heard what JJ used as a slur.
Although, can I just ask,
He's bridging it now to scandalous and immoral.
So the Solicitor General had a tough time, but on this point, if we put vagueness aside, so the vagueness argument is simply that there's not enough guidance for this disparagement standard to get applied in any principled way. But the Solicitor General said, you may be able to come up with a number of examples of registrations that were permitted, but nobody's come up with disparaging marks that were rejected.
How about this? The PTO
or non-disparaging marks that were rejected on disparagement.
The office has registered Fag Dog 3 times and has refused it twice. So,
but can you find a non-disparaging mark that was refused registration on the grounds that it was disparaging? That was what.
Well, it depends on how you define disparaging and who.
Yeah, but the problem with that analysis is it's the government's burden. It's the government's burden to show that, and so that formulation presupposes that it's now the applicant's burden.
You know, the vagueness is a whole other panel. Can we do it tomorrow? And one of the open questions on vagueness is, can you do a facial challenge to a statute on vagueness grounds? And the Supreme Court has said yes, and the Supreme Court has said no. And
the Supreme Court's being vague on that issue.
they're being inconsistent. So, a point we made in our brief, and the government did as well, is that there may be some cases that are really hard, but there are some cases, like the N-word, which are not really hard. And the statute should not be struck down in its entirety facially if it has to be case by case. But we cited cases that say it has to be case by case. Some of the amicus briefs and the football team on the other side cited cases that, and as well as you guys at the end of the table, cited cases that you can do a facial challenge to vagueness. So this case has so much in it. It's unbelievable. I mean, I had no idea what I was getting myself into when I signed on to do this pro bono 6 years ago. But it's even a simple question of how do you bring a vagueness challenge to a statute turns out to be incredibly unclear. But here's a point we made, which I thought was important. The district court agreed with us in our case. When the Supreme Court issued its decision in Marsh v. Chambers, which is a decision that explains when a state or other legislature can begin a session with a prayer, they created which is an Establishment Clause issue. The Supreme Court articulated the test of what the prayer has to contain or not contain. And it says prayer is fine so long as the prayer does not proselytize in favor of a religion or disparage another religion. So, if that's the word that the Supreme Court employed to tell us how to interpret the Establishment Clause, I think it'll be a little embarrassing for them, or hard for them, let's say, to find that the expression may disparage in this statute is vague. I mean, you can do it, right? You can find a way to distinguish anything, but it does seem like an anomaly that we pointed out and that the district judge in our case seized upon.
Yeah, I don't know what to read into it, but Justice Kennedy posed a couple of questions talking about the statute, or a properly drawn statute, suggesting that there might be some, the vagueness concerns might get dealt with in a sort of mandatory statutory
So Roberts will
construction.
rewrite the statute to make it into a tax and therefore make it.
Yes.
There is an irony with vagueness that I just want to touch on. I was actually principally involved in writing the initial brief before the 3-member Federal Circuit panel, and I threw in this constitutional stuff at the time because I thought if we ever got here thinking, this is the issue, the original issue with Simon's application was an evidentiary one. The board had made certain findings that were just simply not supported by the record. The oddity was, though, that the vagueness argument I long thought was the stronger of the arguments, but of course, as a technical matter, was never the one that this court, or for that matter, even the Federal Circuit when it sat en banc, put before the parties. Judge O'Malley below and was joined by somebody. Judge O'Malley wrote the separate opinion on that. But I have just in the 5 years that I've been involved with this case, I've long thought that the vagueness argument was the stronger of the arguments with respect to viewpoint. I guess vis-a-vis viewpoint discrimination.
Interesting. So Meredith, I'm going to give you the last question, and then.
So I guess my question goes to, in the panel before this, we had a discussion with Simon and with Professor Phillips about the difference between reappropriation and reclaiming of terms that can be disparaging versus their use in commercial speech by outsiders. And on one hand, I think for a lot of people, that lines up with their sort of moral or emotional evaluation of this issue, of sort of what's right and wrong. And then I think we've talked about in the First Amendment context that sort of reaching into what people are intending and what their sort of viewpoint is in that context makes it almost worse from a First Amendment analysis of the government's actions. And so I guess the question is there a way for the court to try to thread the needle on that and make a distinguishing test about sort of disparagement that brings into that sort of outside moral sentiment about reappropriation versus outsider use?
I sure hope not.
As a sort of a fundamentally a trademark lawyer, the reappropriation argument, I have to tell you, is one that has hair on it, because it invariably necessarily looks to the applicant's intent. And I think Rebecca will agree with me. I'm sure she'll let me know if she disagrees. That the trademark office can never care about the applicant's intent when they apply for a mark, for a couple of reasons, not the least of which is that intent can change. That is, Simon can register his mark today for purposes of having a political and social message that advocates Asian pride. He can very easily tomorrow decide that he wants to become a raging racist. And so you can, if you're going to look at intent, it can certainly be a proxy for something far more nefarious if that ultimately decides to be a goal. The other issue is, and I think the one that's probably more common in this case, is that trademarks are freely assignable. So you can't marry an applicant's intent. And again, when I say intent, I'm using that really as a synonym for your notion of reclamation, because it doesn't. I mean, Simon may have that goal, but if he decides to assign the mark to me, I don't have that same reclamation objective that he might. So again, from a trademark perspective, I think reclamation, and of course Dykes on Bikes has gone to town on this. I think it's a problem.
I'll stop there. From a First Amendment perspective, it would also look odd to protect speech based on the nature of the speaker rather than for the speech itself. That's just generally not done in other contexts. But look, kind of tying together to something you said, you could imagine the most vilest, racist mark. You register it, that doesn't mean it's a guarantor of commercial or other success in the marketplace. I mean, I suppose the vile racists could try to suppress each other with their competing marks or something, but otherwise, I mean, in the previous panel, they talked about college football teams. Dartmouth and Stanford and all the rest, they changed their names not because they were deregistered their previous trademarks, but because they found it untenable. Or because they were part of an association in the NCAA. But anyway, it wasn't the government telling them to do this one thing or another. So these sorts of private solutions, and ultimately, if people are so offended by the Slants name that it hurts their ticket sales or album sales, or then that'll take care of that issue.
I think the statute just doesn't let you look at intent.
Yeah.
Just the words of it.
And it is one of the interesting things about this is that First Amendment law is not intentionally not responsive to some of the distinctions that we make in society like that because of the difficulty and for all these different reasons. We have more opportunity to have Q&A out at the reception, and thanks to the folks on the internet who were able to join us. Could the people in the room please thank our panelists?
And like I said, I have extra ones, extra hard copies of the Cato and Deplorable People and Organizations brief, if anyone wants them.
All right.
Thank you.
Thank you.
Thank you all. We will. Yeah, we have that data. I can ask Mike. Mike can tell us who's on it now. We actually got a lot of publicity.
How are you?
Young lawyers.
I know. I mean, and I'm the first.
So I kind of missed that.
Please.
I know exactly what you're saying. I don't think
Don't talk about the flexibility I have in the city election.
Applied in the question.
To satirize the law, to show the absurdity of the law, yes. When Doug Kistler in a case called Susan B. Anthony List versus Ohio Election Commission, and then the Confederate license plate case, Walker versus.
Implied that maybe this is not.
That's like they'd be very.
I think so, and it's hard to do. Please, it's hard to do because you have to hit the right tone, and it's not just like using offensive words to be offensive, just to be shock value. That's not the point of it. But yeah, I think I could see. I know Barron fairly well. I could see his kind of sense of humor working in that context. If you can apply that, sure, to what would otherwise seem to be dry, Telecommunications Act stuff.
I did. I remember him saying, if we can write something funny in the brief, that's not ridiculous. But so what area do you focus on specifically?
I'm a constitutional generalist. So over the years, everything from the Commerce Clause and federalism to the Second Amendment and the First Amendment and criminal procedure. I mean, it's kind of like I have a small boutique, as it were, that whatever the big issues of the day are, whether at the Supreme Court or things that come up in national political debate, like is Ted Cruz eligible to be president, or one of these micro issues, the emoluments clause of Trump. So it's,
If you wanted to move away from the mics, I didn't know if you care.
I'm not, I like publicity. This kind of melds my inclination to self-promotion with, Cato's desire to get our ideas out. So I'm happy to have it.
Okay, I guess, thank you for me to ask, because I'm trying to grapple with this. How do you, and maybe you just simply can't, how do you put these two aspects of law together, the trademark aspect of it and the constitutional aspect of it, or do you just simply have to separate them?
I mean, not every, in fact, most IP cases don't involve constitutional issues, and most constitutional issues don't involve IP, so.
We held the line.
Thank you.
That's really all.
You guys have a nice day.
An unpredictable outcome is
Thank you, sir.
a good thing.
There was a section, I don't know if you read Greg Dolan's brief, there was a section on that law.
Well, I clerked with Kirk.
Okay.
So, so.
I mean, he's the one that's would be better positioned to, argue with Rebecca, because I never claimed to, some of the stuff that she was saying, I have no idea.
Yeah. I mean, this is a fascinating case to me, and the bigger point for me is the last thing you talked about what's the scope of IP protection. That's the more important issue for me as a patent person. But good argument. So thanks for coming.
Sure.
Matthew? I just had a question. I went to George Mason economics, so pretty much libertarian. But what I've always wondered is, and I worked at a patent law firm. So my question is, has there ever been a study where you looked at the value of trademarks, where they arose to supremacy without a registration?
The Justice Ginsburg said,
I have no idea.
You take that.
I was just talking to Pat, talk to your IP professors about that. I have no idea.
In for a dime, in for a dollar.
I don't know what pages are anything on that.
What do you say?
Greg Dolan might know something. He's one of the lead professor on the opposite.
Get some rest.
Yeah, I know.
And he has that Lottie Hunt perspective. So I don't know. That's a good question.
So you just want to
That's
say,
monetize the value of registration. That's a very good point.
good to meet you, your support, appreciate it. Let's see what happens.
But I don't know, being that it was like, it's 6 hours.
These guys are saying that
for
the
some reason.
court really hates everybody, maybe that's a good place to start.
20 hours.
Yeah.
And I'm like, this doesn't make any sense.
All right, well, when you see her, tell her we're right, she's wrong.
Yes, may I have your card, by the way? I was
Long day.
so angry.
Well, mine continues. I have a reception to go to and then a dinner.
Shapiro.
Yeah.
And I just thought,
Well, be well, and thanks again for your support.
My pleasure.
I just want to know how this argument would reconcile with the rest of trademark law.
What argument?
His argument about, he's saying that a trademark is a way to silence.
Yeah, the guy.
That doesn't know trademark justice.
That just means,
said,
how do you, are you trying to carve an exception with the trademark law? The First Amendment exception, that's.
Here's a critical distinction. You'll hear Councilor Blackford say, trademarks, it's suppressive and it restricts speech, it doesn't restrict speech. What it restricts is somewhat like a true musician for a commercial purpose.
Good.
Okay? Such that it be infringed upon his primary. So you need to identify the uses of restricted speech. It restricts the commoditization of that speech, which is why he needs to be the only science.
I literally, seriously, I was like, how do you reconcile this scenario? How do you leave the rest of trademark law aside, as applied to the goods and services apply?
The rest of trademark law shall survive. What we're doing here is we're taking it away. Rebecca Tushnet, and we didn't get into this today, has written, it's either a paper or it's in her briefing, that she says, if you apply our rationale, the rest of the trademark criteria crumbles. Functionality, descriptiveness, genericness, and it doesn't, because they are content-based.
What Judge Skagin was saying this morning, I was there, bless you.
Excuse me, thank you.
She was saying that, and I was all the way in the back of the room, and I'm like, no, well, these are subjective, bless you, again.
Right. And of course, the problem with any Supreme Court argument is because it's timed.
Right.
You get out half an answer.
Yes.
And somebody else is jumping on you over here.
Yes.
And you get the Breyers of the world to give you a 3-paragraph question.
Oh my God.
And
I know.
my partner who met us afterwards said,
I had no idea what question he asked you because he was so utterly obtuse.
Was it you? I couldn't see. I was literally all the way in the back, 5 feet, and at one point, who was at the podium? Was you right? Okay, I couldn't see because I was literally all the way there. And I like how you were like, you replied with a question to them, and I was like, yes, answer that. Justice Kagan, I think, was drilling you on the rest of 2A, and I'm just like, but you're deviating from the issue at bar here, and then you said, well, that's not a question here.
Well, they don't care much about that.
Right.
But I wanted to make that point because, if it's not briefed, you're really putting counsel in a difficult position. Okay?
Right.
Because, how are we supposed to answer, especially when, frankly,
Yeah.
these cases,
Yeah.
it really doesn't.
Yeah.
It puts a fine point on pencils, that's all it does. It's all in the brief, which is why we collaborate very closely with UCLA, because those guys are just awesome.
Phenomenal.
They're phenomenal. So, but, look, it is what it is. It happened. It's over. The court hates both sides.
I know, it really does, and I've been following this case since, I read it in my trademark textbook, and then a month later, it was here at the Fed Circuit.
Really?
I was like, let's go. And so then I was up this morning at 5 a.m., and so I was just talking to somebody, like, I feel like a lot of the community at WCL, I don't know that they necessarily, agree with this point of view. But for me, I do. Like, I think it makes sense.
See, and
it's hard, I don't know.
I said this to so many people, when you pull back from the law and you look at the policy issues involved here, they are so incredibly divisive. In fact, they're so divisive that they are dividing the liberal community. Basically, most of the people up there, Ilya was a libertarian, but everybody else is sort of, definitely on the liberal side of the scale.
Right.
We couldn't agree on issues. Tushnet does. We don't agree at all on this stuff. And she took some shots at us. And, it's on the one hand unappreciated, on the other hand, it's an indication of just how divisive this whole topic is. I think one of the problems culturally, right, is the liberals. And I don't know how old you are, but I got kids from like 22, 30, and especially the younger ones. Who says we regulate hard? Hearing that events or it intimidates or anything like that YouTube that went wild last year Yale about students confronting faculty, it was during Halloween, and they were the students were objecting to some of their colleagues going around in certain costumes.
Yes.
Touring.
Yes, I know exactly.
Something like that. And then, so there was, the students confronted faculty, president, and advisor on the meeting outside publicly. They got filmed. And the crazy thing about it is, he's there trying to say to these students, wait a minute, this is called free speech. People have a right to express themselves, good, bad, or indifferent. They were not listening.
I have to look this up again. I agree.
And so this is just so contrary to the values that I have.
Right.
This is suppression of speech. This is not facilitating a variety of viewpoints at all.
Right.
At all.
Right.
And I can't talk too much about that.
No, I completely understand, but I was just like, I was a little.
Sorry to interrupt, John, I'm gonna go home with you, back to the hotel.
Okay, but I gotta find out where I'm going, so let me.
Your point is you may not be, okay.
Well, hang out.
I'm not going anywhere.
Okay. Yeah,
Yeah, sure. I'm gonna grab my stuff. I have to go to my court argument or practice. May I have your card, please?
Sure.
If you have. Where are you guys flying in from?
Well, no, we're just up in, I'm outside of Philadelphia.
Oh, okay.
And then these guys are up in our Hackensack, New Jersey office.
Everywhere.
We're in Delaware, Pennsylvania, New York, all over New Jersey.
Yeah. Yeah. No, I know you can't really talk about, publicly about this, especially this decision.
I mean, I tried to offer some comments, but.
I had to write it down because I was boiling inside. I was just, every time he opened his mouth,
Who?
it was just Shapiro.
Oh, Ilya?
I just couldn't, because a lot of the things he said to me I can't see how he reconciles the idea of trademark as a way to silence, because I think with that argument, you just get rid of trademark.
Yeah, the problem with that argument is it plays into the hands of the people who want to control speech, and who want to control disparaging speech. The response to that truly is simply this. In the limited commercial setting of trademark registration, the Congress has determined that in order to facilitate the largest variety of speakers through trademarks that are going to be protectable, then those who register will have priority, and it extends to those who would seek to claim or challenge their exclusive right to use that mark. That's it. You can still take that mark, politicize it, satirize it, talk about it, debate it, write about it, do anything you want about it.
Register for other types. There's Delta Faucet, Delta Air, Delta whatever.
Yeah.
Dentist.
So
whatever.
there's no suppression,
Yeah.
and but
Yeah.
but again, one of the problems is, there's so many twists and turns in this area of law,
Yeah.
and that it's easy to just get lost in the weeds.
Yeah,
Really is.
absolutely.
Well, listen, good luck in your move.
Thank you. Thank you for your time and for coming to our school.